I call to order this hearing of the Subcommittee on Competition Policy, Antitrust, and Consumer Rights on competition in the digital advertising ecosystem. I'd like to welcome our witnesses and thank Senator Lee and his staff for their work in planning this hearing. He cares a lot about the major bill that's the subject of this hearing, in addition to many other pieces of legislation. We are living in a time of rapid innovation and technological change that is reshaping our economy and transforming how we interact with each other. And we are now seeing how quickly things can change. When we leave here, we're having a briefing on artificial intelligence systems, and I think we all know that is all tied up in the discussions that we have today. Now, advertising, which is really at the center of this market, digital advertising, pays for many of the apps and websites we use throughout the day to read the news, look up recipes online, and stream movies. And like much of the digital economy, there is a lack of competition in digital advertising markets that has been harmful to small businesses and consumers. Today's hearing is about the consequences we are seeing from the unchecked consolidation and a reluctance to enforce the antitrust laws, and it's about what we can do about it. Although Facebook and Amazon have significant ad businesses, there is one company that dominates digital advertising like no other, and that is Google. The ad technology ecosystem connects advertisers, like your local coffee shop, with publishers, like your favorite online newspaper, via systems that price and sell ad space and place display ads on websites. Within that ecosystem, Google dominates the market for platforms and services on the publisher side. That would be the ads that publishers want to place, as well as the advertiser side. So you have the coffee shops that want to put the ads in, and then you have your local newspaper that's displaying the ads. So they dominate both sides, as well as the ad exchanges that connect them. So it's like a three-pronged, and I can see the witnesses nodding, I must be getting something right, a three-part domination. Google has a 90% share of the service that publishers use to sell space on their sites. It has a 40% share of the services that advertisers, like the coffee shop, use to buy ads. And it has a 50% share of the market for ad exchanges that connect those advertisers and the publishers. This end-to-end control gives Google unique access to information about virtually all digital ad transactions and allows it to extract a higher percentage of revenues than they would be able to get in a competitive ad technology market. For example, publishers using Google AdSense to sell their ad space must give Google 32% of the revenue generated. That's a pretty big cut. Research has suggested that Google may be taking between 30 and 70% of every advertising dollar spent by advertisers using its services, depriving providers of original content that are, in fact, struggling to receive their own compensation. This includes many of our news outlets. We have a separate piece of legislation Senator Kennedy and I have on negotiating news content rates, something that's worked successfully in Australia. But the other piece of this is just the overall advertising market that involves news organizations and many other sites. Google's ability to take a large share of the revenues generated by publishers' ad space is contributing to the near collapse of advertising-based revenue models for many news organizations. And this threatens more than competition. It threatens the viability of a free and independent press, which is essential to our democracy. And it is especially hurting the small local radio, TV, and newspapers. Google's market dominance, combined with its huge advantage in consumer data, gives it the market power to exclude its ad tech rivals and maintain its monopoly power. This strategy has been very lucrative. As they say, follow the money. Last week, Google announced first quarter results that included in just ad revenue 55 billion, not million, $55 billion in ad revenue in the first quarter. And you wonder why we are losing what will be a third of the nation's newspapers in just over a decade. You can look right there, 55 billion. That is where the revenue has shifted. And when you don't get paid for your content and you're not able to crack into this trio of monopolies with the publishers and the advertising and the people in between, it's a recipe for disaster. It was about $100 million less, the 55 billion, than in first quarter last year. But 100 million is about a rounding error when you look at numbers that big. What I bring that up for is that it shows that it is consistently that high. The Justice Department recently brought a case claiming that Google has engaged in anti-competitive conduct to establish and maintain monopoly power in these ad technology markets. State attorneys general have also taken action, brought a case, but we know that there are difficult cases to win, which is why this conduct has continued. We all saw what enforcers are up against last week when the D.C. Circuit upheld the dismissal of New York's federal antitrust claims against Meta, citing the Supreme Court's decision in Trinco. One of our arguments here, my arguments, maybe not Mike's, is that the Supreme Court decisions have narrowed the possibility of bringing these kinds of cases, which is another argument for making some changes to the laws. The good news is that there is a bipartisan desire to take action. Last Congress, we passed the bipartisan bill Senator Grassley and I led, that Cicilline and Buck led in the House, to modernize the merger filing fees to make more resources available to the antitrust agencies. We also passed the bill that Senator Lee led, and I was the Democratic lead, to empower state antitrust enforcers. And when these bills were included in the end-of-year funding bill, Senator Lee and I led an amendment to ensure that the merger fee reforms took effect this year. That passed with an 88-8 vote. It's just happy memories of the end of the year. I'm sure you're remembering this. Me calling you at midnight, texting you at 6 a.m. Okay, to address the issues we are discussing today, I'm working with Senator Lee on the America Act to improve competition and transparency in ed technology markets. This legislation is a key part of the work this committee has been doing over the last few years to rein in the market power of a handful of online gatekeepers that are dominating our digital economy. I would note some other bills: the American Innovation Choice Online Act, that Senator Grassley and I have introduced, making it the first tech competition bill last year, voted out of the committee since the dawn of the internet. We did the same with the Open App Markets Act, something that Senator Blackburn and Senator Blumenthal are leading, along with myself. And then I mentioned already the Journalism Competition Preservation Act. I know that on this committee, we are ready to stand up for American consumers, small businesses, and innovation. I see Senator Booker and Senator Welch here, two examples of people who are willing to take on consolidated power in many ways across the economy. We have other examples that I've mentioned on the Republican side. We thank Senator Durbin and Senator Graham for their leadership on these issues, having voted both of them or been co-sponsors of a number of these bills. I want to introduce the witnesses before turning it over. Maybe I'll let Senator Lee make an opening statement, then I'll introduce the witnesses.
Thank you very much. 2.5 years ago, when I was chairman of this committee at the time, this subcommittee at the time, we held a hearing to explore a number of competition concerns rising in the digital advertising market. At the time, it wasn't clear exactly what the solution was, but we wanted to understand the problem before we figured out what solutions might exist. And since then, it's become more clear, and here we're going to discuss that today. The solution lies in the Advertising Middlemen Endangering Rigorous Internet Competition Accountability, or America Act. This is one of the acronyms of which I'm most proud. with legislation. Very grateful not only to my excellent team in helping to put this together. I'm also very grateful for my co-sponsors, starting with my lead Democratic co-sponsor, Senator Klobuchar. We've also got Senators Cruz, Blumenthal, Rubio, Warren, Schmidt, Hawley, Kennedy, Graham, and Vance. And we're just getting started. We'd love to get Senators Booker and Welsh on board with us as well, and hopefully today's hearing will help with that effort. Now, some may be asking, why focus on this? Why all this fuss just about digital advertising? After all, this isn't necessarily the most high-profile market. Consumers don't necessarily lay awake at night ruminating over whether their favorite website is earning enough money from selling digital advertisements, or whether the shoes that they just bought online might have been a little bit cheaper if the manufacturer had saved a fraction of a penny on 1,000 impressions last month that they paid for in their advertising budget. Instead, we do lay awake at night worrying about other things. We spend a lot of time as Americans worrying about things like how big tech firms sometimes track our location at all times, following us to work, to school, on dates, to church, to the doctor, everywhere else in between. And we worry about large trillion-dollar corporations that control our phones, our watches, our movies and our music, our wallets, our books, our thermostats, appliances, home security systems, cars, even baby monitors, fitness routines, and a whole lot more. We worry about big tech firms giving computers to schools to give to our children, whom they then track and monetize by feeding them endless streams of social media, pornography, and other mindless entertainment, shaping their thoughts and psyches, sometimes with devastating or even deadly consequences. We worry about how these companies might use artificial intelligence to shape and influence how we think, feel, and interact and communicate with the rest of the world, ensuring it's only in ways that are profitable for them, of course. But the fact is that all of this technological and financial hegemony rests on one thing: digital advertising. Because digital ads are how you turn data into money. This is the lifeblood of the tech sector in many respects. That's why the first step towards reining in the power and the predation of the monopolist tech companies is to bring transparency and competition into the digital advertising market. This is an important thing. Without that, you can't really do that. This is the lifeblood of the tech economy, which is why the America Act does what it does, to rein in the power and the predation of these companies. Now, the Department of Justice, along with 33 states and territories and numerous businesses, have all seen some of the same problems and have brought antitrust lawsuits trying to address these issues in court. Antitrust litigation, of course, can be an effective tool to bringing an end to significant, intractable competition problems. But these sorts of things take a long time. This litigation will likely take many years to complete. And even assuming that enforcers are successful at the end of the day in that litigation, it's only going to result in an injunction that applies to a single firm. Congress could solve the problem tomorrow and do so in a way that ensures today's monopolist isn't necessarily replaced by tomorrow's monopolist doing the exact same thing. So I'm very grateful to our panel of witnesses here to educate us and enlighten us on these issues, and I look forward to our conversation and ultimately to helping advance the America Act one step closer to the President's desk. Thank you.
Thank you, Senator Lee. I was just noting with our great staff here, Avery and Mark and Kagan, that we don't usually have any natural light in these rooms, so we can say we're shedding light on this very important issue as the curtains are open for the first of many, many hearings. Okay, I'm going to introduce our witnesses here today. I want to also thank Senator Hirono is with us, who's been an early leader on a number of these bills. With us today are Dina Srinivasan, who is a lawyer and a fellow with the Thurman Arnold Project at Yale University. She's also the author of Why Google Dominates Advertising Markets, Competition Policy Should Lean on the Principles of Financial Market Regulation. Also, Professor Roger Alford. He is a law professor at Notre Dame Law School, where he teaches about international antitrust issues and is a former Deputy Assistant Attorney General for International Affairs. Barry Lynn is with us, a frequent flyer on this committee. He is the Executive Director of the Open Markets Institute, a nonprofit research and policy group that focuses on addressing monopoly power and modernizing our antitrust laws. Jason Kint is the CEO of Digital Content Next, a trade association serving digital content companies, and is chairman of TrustX, a cooperative digital advertising marketplace. Last but not least, Todd Henderson is a law professor at the University of Chicago, my alma mater. Thank you. Professor Henderson's research interests includes corporation security regulations and law and economics. If the witnesses could please stand and raise your right hands. Do you swear that the testimony you will give before the subcommittee shall be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. You can be seated, and I will now recognize the witnesses for 5 minutes of testimony each. Ms. Srinivasan, please begin. Thank you.
Thank you, Senator. Chair Klobuchar, Ranking Member Lee, and distinguished members of the subcommittee, thank you for the opportunity to testify before you today. The America Act is really just a simple piece of legislation that'll fix a major problem at the heart of online markets. The problem that the bill aims to, the problem that the America Act aims to fix is simple. You see, entire sectors, as we've discussed already, of the U.S. economy depend on being able to buy and sell online ads. And this includes entrepreneurs who might buy ads to reach new customers and grow their businesses, and it includes content creators and media businesses selling ads to fund their operations and to keep their subscription prices for consumers low. It's an industry today that is not small, it's worth hundreds of billions of dollars. Now, people used to buy and sell ads in person. Say the local owner of a restaurant calling his newspaper and haggling over price. That is no longer the case. Today, as we've begun to discuss, ads are bought and sold at lightning speed on sophisticated exchanges. Ad companies have modeled their exchanges after stock exchanges that we're familiar with, like the New York Stock Exchange. So now the owner of the local restaurant must go and use an ad broker, just as he'd have to go use a stockbroker like Fidelity to buy ads from his newspaper that are now trading on exchanges. And he must trust his broker to act in his interest and to fetch him a good price. The problem today is that the companies that operate the new ad exchanges and brokers operate without any of the common sense rules that Congress has enforced on Wall Street for nearly a century. There are no rules that manage conflicts of interest. There are no rules that require brokers or exchanges to be open, honest, and transparent with their own customers. The industry is most certainly not policing itself. That's the essence of the problem. I'd like to share a few concrete examples of what's wrong with the picture. The company that owns the major ad exchange also operates on the sell side, also operates on the buy side, and also sells advertising itself. They don't even bother keeping the different divisions internally separate from one another. So imagine that restaurant hands $1,000 to its broker to go buy ads for its business, and that broker turns around and uses its customer's money and information to trade against that customer, to force ads to clear on its own exchange, even though that decision is bad for its customer and costs its customer more money. For many years, on the other side of the equation, websites and apps were at the mercy of the largest broker using deceptive tactics and exploiting information advantages when routing trades to exchanges, resulting in those websites and apps making up to 50% less revenue than they otherwise would. This might sound abstract, but imagine for a minute if the Washington Post is suddenly making 50% less revenue than it otherwise would. As Senator Klobuchar mentioned, the harmful behavior not only hurts the bottom line of these online businesses, but it has broader implications to institutions critical to the strength of our democracy. In dollars and cents terms, the burden on the public is real. Financial exchanges charge far less than 1% on a typical stock trade. In advertising, with no rules, no transparency, and runaway conflicts of interest, the brokers, exchanges, and exchanges in the middle take anywhere between 30 to 50% of each and every trade. Now, there's nothing inherently wrong in a capitalist society with exchanges and brokers charging what the market will bear. The problem, instead, is that in advertising, they are only charging that much because they're not managing their conflicts, they're trading on inside information, and they're not being open, honest, and transparent with their own customers. Those practices impede the process of competition itself, and they cause prices to soar. And when the cost to buy and sell ads soars, that increases the prices of all goods and services being advertised. One thing that I thought might be helpful to mention is sometimes these things, again, are abstract, and we might think stock exchanges are different than or stocks are inherently more important than stocks, but entrepreneurship, the last time I checked, was a fundamental source of wealth creation for Americans, and advertising is really a critical part of that. Thank you for your time today, and I look forward to answering your questions.
Thank you very much, Professor Alford.
Thank you, Senator Klobuchar. I've actually read your book, and I'm a huge fan of that book and the work that you're doing with respect to antitrust initiatives. And
I assume you've read Senator Booker's book as well,
I've read
and
that.
Senator Lee's book, What Happened to
That was the most obsequious comment I've heard in 10 years as a senator.
Hawley's
I just
book
want to
as well.
mark my
Rono's
protest.
book?
So I'm a conservative antitrust scholar and former Deputy Assistant Attorney General in the previous administration, and I'm here today to speak in support of the America Act. Let me begin by saying that everything about online display advertising is enormous. According to the DOJ's complaint filed in January of this year, publishers sell more than 13 billion advertisements every day. The daily volume of digital display advertisements grossly outnumbers by several multiples the average number of stocks traded each day on the New York Stock Exchange. Not only is the volume staggering, the margins are also staggering. While the New York Stock Exchange, as Dina just mentioned, makes less than 1%, less than $5 on a $100,000 stock trade, Google intermediaries make approximately 40% or $40,000 compared to the NYSE's $5 on a $100,000 ad campaign. As a result of Google's revenue, it makes approximately $280 billion a year or $767 million a day. It makes more revenue from ads in 1 week than Twitter makes in a year. A third aspect about online advertising that is enormous is the enormity of the problem. It is almost completely unregulated market with neither litigation nor legislation curbing the harmful conduct. Nearly identical practices in financial markets would result in severe fines and even criminal sanctions in the case of insider trading, but are completely unregulated here. Just as insider trading in the early 20th century was commonplace, according to one commentator, historian, taken as a matter of course without indignation, without even a passing comment in the early 20th century, today we have the exact same problem in the display advertising markets. Google makes billions in revenue from its dominance at every level of the ad tech stack. Some will tell you that these markets are competitive because they are vertically integrated. But vertical integration can be beneficial if it eliminates double marginalization. Here, Google is enhancing triple marginalization with high margins on the sell side, high margins on the buy side, and high margins on the exchange in the middle. As introduced, the America Act prohibits entities with significant digital advertising revenue, only the largest of the large advertising players, from owning and operating entities across the ad tech stack. In the digital ad tech market, there are several advantages to structural separation. Let me offer just a few. First, structural separation recognizes the limits of regulatory behavioral remedies that are difficult to devise, implement, monitor, and enforce. The same reasons they prefer structural remedies in merger review is the same reason it's important here. Second, structural separation eliminates or minimizes the conflicts of interest that Dina just mentioned. Third, structural separation eliminates or reduces the risk of cross-subsidizing and steering products and services to your preferred exchange rather than to a more competitive exchange. Fourth, structural separation improves transparency and information flows. And fifth, structural separation eliminates or reduces incentives to restrict competition. Finally, let me close by emphasizing why conservatives should support the America Act. I want to emphasize that the legislation is consistent with conservative antitrust values, and the list of co-sponsors that have been garnered already just in this early stages of the bill underscores that point. While litigation is appropriate to curb big tech abuse of power, it is not sufficient. I obviously am a strong supporter of litigation. I'm involved in the case brought by Texas against Google, but it is not enough. Attorney General William Barr, in his memoirs, has a whole chapter on big tech. And there are two reasons, according to Attorney General Barr, why targeted regulation of big tech is important as a complement to antitrust litigation. And again, remember, this is after having brought the search case against Google and recommending the ad tech case. So according to Attorney General Barr, these markets have powerful network effects, prone to monopolization, and second, they impact not just competition, but the collection of personal data and the free flow of information. According to his memoirs, let me just quote, "I have natural reservations about imposing a regulatory framework on market activities, as most conservatives do, but the reality is that some markets and market conditions require a degree of regulatory intervention. In this case of big tech's major platforms, it is hard to see how the challenges they pose to competition, privacy, and the free flow of information can be addressed in the absence of a regulatory framework." I look forward to taking your questions. Thank you.
Thank you very much for those startling statistics, Professor. Thank you. Next up, Barry Lynn.
Chair Klobuchar, Ranking Member Lee, members of the subcommittee, thank you for inviting me to speak on this extremely important topic. It's good to see you all again. The America Act is a very smart idea that would do much to properly structure a market for online advertising. We at Open Market strongly support this idea and commend Senator Lee for working to restore traditional common sense regulation and to ensure transparency and eliminate conflicts of interest. Open Markets also supports the ideas behind the America Innovation and Choice Online Act and the Journalism Competition and Preservation Act. We view these as vital also to rebuilding a more competitive and open internet and more democratic markets for news and debate. That said, we do not believe these ideas, even taken together, are sufficient to address the full array of threats posed by the power and control concentrated in Google, Facebook, Amazon, and Microsoft. None, for instance, addresses the power of the middlemen to manipulate what citizens read or whether they read at all. Consider Facebook's dramatic recent shift from news to video. None deals with the use of platforms to censor and manipulate debate. Consider Elon Musk's seizure of Twitter and his gleeful use of that platform to silence critics. None deals with the routine extortion by these gatekeepers of every company and individual who depends on them to get to market, a form of theft that is often booked as advertising. The people in this room and the wider community fighting to protect democracy from monopoly have made great advances these last 7 years. In understanding the nature of the threats posed by monopoly power and control and the source of monopoly and the ideas of Robert Bork and his allies. In building enforcement capacity and the ability to cooperate across the aisle and bringing lawsuits to limit the powers of these corporations. But the time has come to admit one big failure, which is to recognize that corporations like Google and Amazon have today become essential infrastructure for communications and commerce. This failure has allowed these corporations to develop business models based on forcing users to pay them to open the gates to the market for goods, for news, for ideas. In short, we allowed these corporations to develop forms of political power that are overtly autocratic in nature and that pose far graver threats to democracy and liberty than any plutocrats of the Gilded Age. That's why Open Markets believes it is so critical that enforcers in Congress move now to impose a system of non-discrimination on these gatekeepers, one that will require them to provide essentially the same service to every individual and business who depends on them. This principle of absolute equality of treatment traces to the Declaration of Independence. It is a core goal of the Constitution. It is the practical foundation for how Americans regulated every network, monopoly, and other powerful gatekeeper throughout our history. Senator Sherman, in a speech backing the bill that bears his name, explained why. It is the right of every man to work, labor, and produce in any lawful vocation, and to transport his production on equal terms and conditions and under like circumstances. This is industrial liberty and lies at the foundation of the equality of all rights and privileges. But in the 1980s and 1990s, Bork and other radical pro-monopoly actors overturned these principles. Today, we face the consequences, and now the reckless and chaotic imposition of generative AI by Google and Microsoft threatens to make these threats worse. The good news is we have an almost all-purpose solution, one the American people has proven time and again in use on technology after technology, the railroad, the telegraph, electricity, broadcast, the internet itself. In November 2017, Senator Franken, when he was a member of this committee, pointed in the right direction. As tech giants become a new kind of internet gatekeeper, he said, I believe a basic principle should apply here. No one company should have the power to pick and choose which content reaches consumers and which doesn't. The time has come to take up Senator Franken's mission and finish the job of making Google, Facebook, and Amazon safe for American democracy and American liberty.
Thank you very much, Mr. Lynn. Mr. Kent.
Thank you, Madam Chair, Ranking Member Lee, and Senators. My name is Jason Kent. I'm the CEO of Digital Content Next. DCN is the only trade organization dedicated to serving high-quality digital content companies that manage trusted, direct relationships with both consumers and advertisers. Our membership includes more than 60 media companies and thousands of brands from every segment of the market, from large to mid-sized companies, some who have been around just less than a decade, others for more than a century, all creating original news and entertainment over the internet. Our members include the New York Times, Wall Street Journal, Washington Post, Disney, Paramount, Philadelphia Inquirer, Vox Media Group, the Daily Caller, the Financial Times, among others. As background, I spent my first 20 years of my career running major digital media businesses, beginning with the very advent of the web in the early 90s. Our DCN members create trusted, original content funded primarily through advertising. Yet while advertising is woven into everyone's digital lives, most people have only a vague idea of how it works, including how closely its plumbing has evolved to resemble a stock exchange. In barely 3 decades, digital advertising has quickly evolved into a high-speed marketplace in which a variety of pricing, placement, targeting, and auction levers are pulled in milliseconds as we go about our digital and physical lives. This is now the largest advertising market, trading at more than $200 billion of advertising per year in the US, executed in real time entirely by machines. And like in the financial markets, brokers buy or sell on behalf of clients. To guard against fraud in the stock exchange, Congress enacted common sense rules nearly a century ago. These rules prohibit the biggest companies from operating on both sides of the market. These rules also require transparency and impose a duty on brokers to get the best deal for their client. In short, these are rules that every American can understand and support. Unfortunately, there are no common sense rules in the digital advertising marketplace. As a result, the supply chain is murky and rampant with fraud, insider trading, and hidden fees. Ad tech companies often arbitrage over users' data to use on behalf of other clients or for their own profits. Google, the most dominant company in the digital ad marketplace, enjoys a stranglehold over the entire supply chain since they offer the most popular software for advertisers to buy ads, for publishers to sell ads, and the most dominant exchange where bids are placed and winners are chosen. Google's dominant position is so problematic that a group of bipartisan state attorneys general have filed suit to end the monopoly. And earlier this year, the Biden administration's Department of Justice filed a similar suit, which was the result of an investigation by the Trump administration. Perhaps the best illustration of Google's dominant position was the quote that's been mentioned in government suits. Yes, a Google executive said the analogy would be if Goldman owned the stock exchange. I kid you not. How that plays out in reality in the lawsuit allegations and industry conversations is when Google tells a publisher that, hey, if you want to have access to all this advertising demand over here, that's your lifeblood, then you also have to give me access to all your user data and your browsing history across the website, AKA tying. Digital advertising is a critical driver for our economy. That's why DCN wholeheartedly supports the American Act, which was introduced by Senator Lee and co-sponsored by many of the senators mentioned. The bill would require transparency, promote competition, reduce obvious conflicts of interest, and stop market abuses by the most dominant companies. The bill lays out basic common sense rules for the digital advertising marketplace that, once again, all Americans can understand and support. Ultimately, the focus of the discussion around this legislation will be the breaking up of Google. That will be the headline. Don't get me wrong, it's certainly a necessary and good idea. But there will be also some who argue, why not just let the courts, let the antitrust lawsuits first follow through before we pass new laws? Well, I have two reasons. First, as it relates to Google, we don't have time for a long appeal process as they've increasingly sucked the oxygen and the potential for profits out of the news media industry. Second, the legislation isn't merely about the behemoth. It also importantly addresses transparency and eliminates conflicts of interest for even the middle-sized ad tech companies so that all brokers have to serve their clients' interests. By lowering costs for publishers and advertisers, the America Act will also lower costs for consumers, and it will help protect consumers' privacy. As Senator Lee previously said, this is not a bill that's either liberal or conservative. It's not Republican or Democratic. This is just a good business process bill. We agree wholeheartedly. We applaud your work on behalf of the free and local press, small and large, old and new. Thank you for inviting me here to testify today. I look forward to answering any questions you have.
Very good. Thank you, Professor Henderson.
Thank you for having me. It's a great honor to be here. I have 3 points to make for the subcommittee today. First, monopolistic markets are associated with rising prices and restricted output, but digital advertising has in recent years demonstrated the opposite, with ads becoming cheaper and more effective. Second, ads are not stocks, and any claim that they should be regulated the way stocks are is based on a fundamental misunderstanding of how securities regulation works and why it exists. Third, the divestiture portion of the act may have perverse effects on competition and innovation. Congress should carefully consider what this market would look like if this bill is passed. First, let me talk about the market for open display ads, which it's worth noting is a small part of the online ad market, which is in turn just a small part of the overall ad market, which is just an even smaller part of the overall marketing budget. Senator Klobuchar mentioned $55 billion for Google. That's a giant number. That's all of their ads, which include search and other things. The open display portion, which is what the America Act is about, is much, much smaller. I think it's about $7 billion. This market is dominated by a couple big firms, Google and Facebook. But as Senator Lee has repeatedly warned, big is not necessarily bad. We have to understand why and what harms, if any, flow from bigness. Importantly, these intermediaries are vertically integrated and operate in two-sided markets. And they're trying to optimize across that entire operation of advertisers and publishers. I understand why the Washington Post is upset that they see a 50% reduction in their ad revenues. But there's advertisers and consumers on the other side. One has to think about the net effects on all sides of that market. When you do that, you can see in the last couple of decades, just in the last 10 years, digital ad spending has grown about 20% per year on average, and prices have fallen 4% per year on average. These are consistent with a highly competitive market. And as the UK Competition Authority found, the 30% number or 70% number that Senator Klobuchar mentioned, Google's was at the industry average. The evidence needed for a massive remaking of a giant industry should be compelling and overwhelming, not based on anecdotes and hypotheticals. Let me talk about the analogy to stock markets. The logic is simple, and we just heard it from Mr. Kent. Google should be barred from acting as a broker on its own exchange, just as Goldman Sachs is prohibited from owning the exchange on which stocks are traded. But this is factually false. Goldman Sachs does not own the New York Stock Exchange, but it owns a different exchange called Sigma X. If your broker recommends you buy a company's stock and you accept their recommendation, that broker can route your stock trade to the New York Stock Exchange. They can route it to their own wholly owned exchange, Sigma X, Or, even more remarkably, they could fill your order from their own inventory. About half of stocks are traded in venues owned by stockbrokers. It's because of the lack of physical separation in stock markets that the SEC has adopted the best interest rule. That's Rule 611 of the National Market Securities Rule passed in 2005. It's worth noting that notwithstanding the fact that this has been a rule since 2005, it has required a massive bureaucracy inside of firms and in the government to try to enforce it. And yet, only 43% of trades happen at the national bid offer price, which is the best priced rule. In fact, exchanges market to their customers tools that allow them to sell at something less than the bid ask, the national best price. So invoking this in stock markets is one thing where there is one price for Google, and that price is the same for every person on planet Earth at a particular time. In contrast, in the ad markets, every ad at every second on every web page for every different person is priced differently. Ensuring that stock market trading is fair is a monumental task for regulators. Doing this for online ads is unimaginable. There's a bigger issue with the analogy. We have aggressive regulation of stocks because they are the importance of stock prices to consumers, and stock markets are the nerve center of the capitalist economy. Stocks are the largest source of savings for individual Americans, and while advertising is important, it plays nothing like the role stocks do in our society. The stock market, by the way, is also 700 times bigger than the online ad market. 700 times bigger. The last thing, and I have to close, I'm running out of time, is the net effect of this bill on competition might be really perverse. Amazon is building its own business internally. They did this and routed trades through Google. Once it got big enough, they stopped doing that because they built a rival business that was important. Walmart and Target are doing the same thing. If you make it such that once you get to a certain size, then you have basically got to get rid of that business, you're going to impede companies from trying to build their own internal improvements. I'll close there. I'll just say I like the transparency aspect of this bill, and if my vote mattered, I would vote for that. The other parts are more troubling to me. Thank you.
Okay, thank you very much. I'll get started, and I want to thank Senator Tillis, Senator Blumenthal for being here. And Senator Blumenthal, we mentioned your leadership on the App Store bill. Thank you. As the daughter of a newspaperman, I have watched closely as local journalism has seen its content and ad revenue siphoned off by digital platforms like Google and Facebook. You mentioned this, Mr. Kent. How has Google leveraged its monopoly power to squeeze publishers like local newspapers out of ad revenue that they would receive if there was a competitive market?
Over time, Google and Facebook, Google in particular, have absorbed most of the incremental growth of the industry, and they've done that by a pervasive collection of data across the web. Google has tags and pixels and listening devices basically on nearly 80% of the top 1 million websites. Facebook does across 8 million plus websites, according to regulator data and research. So they're collecting and mining data across the web and using that to generate the most profits possible because they dominate the supply chain.
Mm-hmm. From your perspective, working directly with publishers, what are the biggest threats to publishers from a few tech giants controlling almost every aspect of the tech ecosystem? How are you addressing those threats?
Well, antitrust is key to us because most of the downstream harms that we've seen, whether it be lower quality content, disinformation, not being able to fund journalism in newsrooms, data abuse, concerns about censorship and the way those are all downstream harms from what's upstream, which is a perverse amount of market power by just a couple companies. And so anything in the area of antitrust or data protection that actually aligns the consumer's interests with the content and the news and entertainment that they actually want to consume is very valuable. Other legislation like what you're working on with the JCPA, where there's a duty then to correct imbalances in bargain power, is also very important to the future.
Okay, thank you. One of the concerns that we have discussed here, and I've heard from both publishers as well as advertisers, is that there's no way to verify limited data that Google and Facebook provide about where ads are shown, to whom. and for what price? Even you, Mr. Henderson, Professor Henderson, that doesn't agree with this, this bill, have noted that transparency is a good thing. One example of this, Facebook was sued by advertisers in 2018 for lying about how many people an ad could reach. What information about ads do you think should be provided to advertisers and publishers by ad platforms? And the secondary question, how has a lack of competition empowered Google and Facebook to limit transparency? So why don't you get at that? Because I believe that this bill would help give advertisers greater insight into what's going on and whether their digital ad campaigns are even effective. It's hard to know. So anyone want to take any bit of that about what information you think it should be provided, and also what we could do better?
Sure, thanks, Senator. One thing that Professor Henderson mentioned, and this is sort of thrown around a lot, is that the price of ads has just gone down. So nothing to see here, folks. One of the things that the bill does, which I think is great, is it requires brokers to disclose certain information to advertisers. And that information will allow them to audit whether what they're buying is good quality or whether what they're buying is bad quality. And so one of the things that might happen is finally we'll be able to actually measure whether in fact the effective price of ads is going down or whether it's going up.
Mm-hmm.
Can I just add one other small comment, and that is that, you would think the publishers and the advertisers would both know what the price was for the impression that was sold. The advertisers know what they paid, the publishers know what they received, but neither the publisher nor the advertiser know what the costs in the middle were. And so there's a disjunction of knowledge about what publishers received and what advertisers paid, because this intermediary margins are really, really large. Mm-hmm. And it would be like having a stock trade without knowing what the ultimate price was, or a sale of a home without a closing sheet. And so that's a very simple example of transparency.
Mr. Lynn?
Yes, thank you. In an earlier life, I ran a magazine called Global Business. It was a 100,000 circulation magazine. It was 4-color, perfect bound, 96-page monthly magazine. We lived 100% off of advertising. One of the things that we did in this this period a long time ago is we spent about 7% of our revenue every year auditing our readership to make sure that advertisers understood exactly who they were getting and how they're getting it. That was a long time ago. That was essentially before the internet. I would say that advertisers back then were better served than they are right now.
Okay, very good.
Go
Professor Henderson. I'll go back to, I have one last question our colleagues have to.
Okay, I just want to add, I said I was for transparency, and I think that's fine. I think, Louis Brandeis said it well, shine a light on things, as you said, Senator Klobuchar, when we started. I should note, though, that's a little bit misleading because, as I mentioned, Google, the UK Market Authority, found that Google's rate that they charge is in line with their competitors. And if nobody had any idea how much these intermediaries were taking, they would have incentives to jack, Google could get away with charging anything because nobody knows what they're charging. They're charging a market rate, the market rate of their competitors. And I'll note that the average large publisher will use 6 different ad platforms in a year, and the average advertiser will use 3 different platforms. So it's not like this is the only game in town. And if Google is fleecing everybody, I'm from the University of Chicago, so I'm contractually obligated to say that I believe in markets. And if Google was absolutely fleecing people, given that the average person uses 6 or 3 or 6 different other ad alternatives, they would be taking their business to those places. Now, if they are, as you said, Senator, committing fraud by deliberately misleading people, then we should have no tolerance for that. We should go after them. Yep. But the threshold for breaking them up, I think, should be a lot higher than that.
Okay, Mr. Kent, you want to respond?
I was just going to say that, I heard the point earlier from Professor Henderson why stocks are different than advertising. I don't think we're arguing they're the same thing. But advertising in digital is a high volume. We heard the numbers from Roger that the volume of advertising impressions per day at that rate, the average ad translates to about less than a penny per advertising. That's ripe for fraud. Those are the types of markets, large volume, low price. A CEO of an ad tech company recently told me that Google and the Trade Desk are non-transparent black holes. Nobody has any clue what's going on inside them. And so we need to actually have some transparency, because the way it translates is that local publisher gets a check every month from Google, and they have no idea what's behind it.
Okay, one last example I want to use of my own experience with this, and why I know that they have info and they're targeting people. One of the ways that Google is able to leverage its market power to disadvantage its competitors is by drawing on that vast amount of personal data it has on people, as well as the lack of any federal privacy legislation to limit how it can use the data. So you have this twofer problem. So I wanted to show this ad only because, so this is a pop-up ad against the self-preferencing bill. Okay, and I only find it funny because I do want to thank the lawyers of Google who put that little could in there. So it says, Senator Klobuchar with the little, my colleagues will enjoy this, could break Google Maps, okay? This gives me a lot of power, Senator Lee. What?
Just the context throws me.
Yeah, I know.
You don't want it to suggest you could break. That's not the message.
Well, that's exactly. I do wonder about it. And if we want to look at the other ones and show these, I'm going to get to the punchline in a minute. These are harder to see, but these went all over the place. That I would erase Amazon Basics and that I would break. This one is interesting. Another little could break FaceTime. Okay, so who saw these? Members of Congress saw these. So these were targeted in Washington, D.C. for members of Congress when they were home against the bill, and this is part of the over $200 million advertising campaign put forth by Chamber of Progress, or as I call them, Chamber of Lack of Progress, which is the big tech companies' front group. And so, but what is interesting to me is I heard about these ads from who? Other members of Congress. They were targeted, so they saw them. I'm not going to put their names forward on this thing, but I had multiple calls by members of Congress. So I guess I would ask you, Ms. Srinivasan, if that surprises you, that they would be able to have this data to target people so they scare them from supporting our bills, because they don't want to have these really scary ads that they're breaking into be put up on sites where people are just looking up TV shows like I was doing. Okay. Go ahead.
It doesn't surprise me. When Google bought DoubleClick way back when, one of the things that it promised to do was to keep customers' data separate. Of course, it purchased DoubleClick, and then after it gained market power, it started to use that information, and it can use that information now for different trading purposes, whether it's to hyper-target ads like that. That is data that's originated on the publisher side, on the seller side, that Google is gaining by virtue of its position as publisher's broker, and now it's using it on the other side to target ads and to inflate its trading revenue. And so that's one of the things that this bill would target and prohibit.
Exactly. And of course, the ultimate interesting part is they're using it to target people on a bill, using their own monopoly power to target a bill that tries to do something about their monopoly power. So I just think it shows what we're up against, but it also has to be revealed to the public. So with that, I'm going to turn over to Senator Lee.
Thank you. Ms. Srinivasan, let's start with you. You've looked at the ad tech industry from multiple angles. You've looked at it from the inside as within an ad tech company, and you've also looked at it from the outside as a legal scholar. And so, Ms. Srinivasan, is your assessment, what are the biggest harms to competition that we currently face in digital advertising? And do you think the America Act would be effective in addressing those harms?
I do think the America Act would be effective. Based on my research and studies, I'm not aware of any exchange market that is vertically integrated the way ads are. The biggest problem, to answer your question directly, is that they're not self-managing conflicts of interest. And there's very little transparency in the market. And so we don't know whether prices are going down, whether prices are going up, whether what I bought was good, whether it's fraudulent, whether it existed, whether it didn't exist. And the bill addresses all of those problems.
Thank you. Mr. Alford, sometimes we expect vertical integration in most markets, in fact, to create some efficiencies that can end up benefiting consumers, enhancing consumer welfare. But it's not always the case, is it? I mean, when there are substantial barriers to entry or when there are switching costs, it can also lead to foreclosure that keeps out new competition and either entrenches or expands monopoly power. How has this worked out in ad tech? Is it more what we would expect in some industries where it increases efficiencies, or is we have substantial barriers and switching costs leading to foreclosure?
Yeah, thank you for the question. So the prevailing wisdom about vertical integration is that it's beneficial because you eliminate double marginalization. You don't, the wholesaler takes one profit margin and the retailer takes another profit margin, and you eliminate that if there's vertical integration. But of course, that's assuming you're all on one side, right? In this situation, we're talking about vertical integration, as Dina just mentioned, in an auction on both sides across the spectrum. And in that situation, you have the ability to arbitrage your fees, and basically where there's competition in different segments of the stack, you can lower your prices, and when there's not competition, you can raise your prices. Todd Henderson calls it subsidization, but it's really arbitraging and recoupment, not in a future time, but actually in present time, just in a different segment of the stack. And so you have massive conflicts of interest. Imagine the buyer trying to get the best price at the best quality product at the lowest price, and the seller trying to get the highest price. And they're calling that vertical integration. That's just not the way that you typically think of exchange markets working.
Mr. Kent, what are the challenges that publishers face in their unique world? The vicissitudes of that business are somewhat unique. What do they face when it comes to navigating the digital advertising ecosystem?
I think the primary challenge is the scale that comes with with Google and Facebook, and the lack of transparency into the supply chain, coupled with, so you've got the scale that makes it really easy to buy, coupled with this pervasive collection of data in which an individual publisher can't compete. I think one of the things that people often miss is that Google and Facebook, according to the regulator report that Professor Henderson keeps referencing, which was quite damning for Google and Facebook, by the way, it also concluded that most of Google and Facebook's data actually doesn't come from people using their products. It comes from third parties, when people are actually choosing to use other products. And so that underlying collection of data is a way that an individual publisher can't compete.
And now, one tech firm, as we were preparing for this hearing and talking about this bill, one tech firm told my office that separating the buy side from the sell side of the ad tech business to eliminate conflicts of interest could actually cause publishers to pay more. Do you share this concern, and what's your assessment of it?
No, I think that word "could" is being placed again in a very operative way. Ultimately, that's why the second tier in the legislation is so important, the best interest and best execution obligation, because it aligns then the interest with the principle on the end, and so that will ultimately drive down price with competition. And the idea that by having a single company that controls the entire supply chain, that has a duty to maximize, it's not even just Google, the entire ad tech landscape are for-profit companies trying to extract as much value out of that supply chain from the consumer and publisher and the advertiser on the endpoints. And so having actual competition and best interest obligations is a huge win.
Okay, on that topic of collecting data, and lots of people, Ms. Srinivasan, I've heard allegations suggesting that Google cuts off publishers who don't consent to having Google collect data on their web visitors, their visitors to their websites. How would the America Act address that problem?
Currently, publishers don't really have a choice when they're using an intermediary on the sell side. Google's intermediary on the sell side has over 90% share of the market, and that's why it's being sued by so many state attorneys general in the Department of Justice. So what the bill does basically is it will create competition both on the sell side and on the buy side and in the exchanges in the middle. And that competition will cause firms to enter that offer better terms with respect to data. They'll start competing to offer better privacy and better terms.
So would it be fair to say that, perhaps counterintuitively, or it's not necessarily obvious to someone looking casually at this legislation, you could end up, through this bill that focuses on competition policy, you could end up enhancing the privacy interests, the ability of consumers to protect their own privacy, the ability of people who operate one website or another to protect the privacy of those who visit their websites. Is that fair to say?
Absolutely. I would expect it to have that immediate effect.
Okay. See, my time's expired. Thank you, Madam Chair.
Okay, very, very good. Good question. Thank you, Senator Lee. Senator Hirono.
Don't you love antitrust? You say, what?
No, it's great. Go ahead.
Thank you for holding this hearing. So I heard you say, Professor Alford, that vertical integration, when we're talking about the digital advertising, is not how we usually think about vertical integration in the, say, in the antitrust case where the refinery owns the gas stations. So that's so much easier to understand than vertical integration, if there's such a thing, even in the digital space. Can you explain a little bit more why there's such a tremendous conflict and what's going on in digital advertising?
Yeah, happy to do that. Thank you for the question. So again, this is a situation where you have multiple monopoly practices going on. You have unbelievable power with respect to the information that is provided to make the ads targeted advertisements. You have monopoly power with respect to the publisher side. So if you're going to try to offer your services, a publisher has to pretty much use a Google broker. And then you have extraordinarily high shares in the exchange in the middle. And then you also have just unbelievable power on the buy side, on the advertiser side. And then above and beyond all of that, then you have their own owned and operated products like search and like YouTube, where if you want to use YouTube and do digital advertisements on YouTube, you have to use Google broker products. And so as a result of that, because of the multiple layers of control that they have, they can basically steer people to Google products, and they can charge prices across the stack to their advantage. And equally important, they can use information over here and take that information and use it over here and basically arbitrage the information and the price that they're going to adjust. So it's not just insider trading where they're using it for their own advantage. They're using that insider information for the opposite side of the transaction's advantage. And so it's a really, really unusual environment, and we just don't see that in auction markets. Can I also make one final comment in responding to Todd Henderson? He says, well, it can't be that big a problem because prices are declining. Well, he's assuming that it's only monopolization on the sell side, but obviously you can have a monopoly on the buy side. That's called monopsony power. And if you have all the power on the buy side, then the result you would think would be prices are going to be reduced. And we see that with the DOJ's challenge to the Penguin merger. There was a concern about monopsony power. Just because prices go down, if you're the buyer, that's exactly what you want as a monopoly.
So I'm assuming that the rest of you agree that the way the professor is describing what's going on in digital advertising, that this kind of complexity where so much of what happens is owned by, is controlled by entities like Google and Facebook. Do you agree that that's a pretty good description of what goes on? Yes. So what is the...
I don't agree, but let me just. I just want to respond very quickly to two things that were said. So first of all, Ms. Srinivasan said there is no market with this vertical integration. As I mentioned in my opening remarks, this is the stock exchange. It has the same features. Goldman Sachs represents buyers. It represents sellers. It owns exchanges where things are traded. I have a paper that I submitted to the committee that's 54 pages that lays this out in detail. So you can take a look and see if I'm right or not. One other thing to respond to Professor Alford. This market seems strange because it has this vertical integration. It's not just about double margins on both sides. It's about economies of scale and network effects.
Okay,
If you were building
I
an ad market
understand.
from the ground up, you would make it centralized.
I am not looking for a debate among the people testifying. I'm trying to clarify some things in my own mind. I understand that you have a very different perspective of what needs to happen. So okay, I have a question for Ms. Srinivasan. There was a nonprofit last year called the Center for Intimacy Justice, and they released a report alleging that Meta was systematically blocking advertisements about women's healthcare products on its platforms because it was classifying them as quote-unquote adult content. If there were many different digital advertisers, that would be less problematic, but Meta is a dominant player. So for Ms. Srinivasan, you've highlighted a number of problems with the dominance of a few platforms. What do you think about the idea that these platforms are gatekeepers of the advertising, who can decide what kinds of ads can be placed on their platforms? And will the America Act prevent that sort of thing from happening?
Thank you for the question. I guess we see it's a simple answer, but basically when we have more competition, two things happen. You have competition on price and you have competition on terms and conditions. And so if we fix competition, we would expect firms to start competing to be more intelligent about these types of decision-making that can be sloppy. So yes, I would expect the Act to address and fix that problem.
Thank you.
Thank you very much, Senator Rona. Senator Blumenthal.
Thank you, Senator Klobuchar. Thanks for this really important and informative hearing, and to the ranking member as well. I support all three bills that are before us today, and an additional bill, the Open Apps Market Act. I want to thank all of you, particularly Ms. Srinivasan from Yale, for being here today. And you have highlighted what I think is a central challenge here in your testimony, how to go from the abstract to the real. Not just in this hearing room, but for the American public, because there is a fundamental difference between what's happening here and the stock exchange, which is people make or lose money every day, and they watch what's happening on the stock exchanges, and it's sometimes confusing and frustrating and enraging, but they have tangible results. And I think the challenge here is to go from that abstract to what in real life makes a difference for them, because Senator Lee has said that, and I've said that, this 40% that's added by Google and others, that's a tax. That's money that they should know is added somehow to their bill. How do we inform them? And Ms. Srinivasan, you've written about the hidden fees and the opaque financial practices. How do we make clear to them that their newspapers are going under? The New Haven Register and the Hartford Courant have been hit hard by these online advertising practices. It makes a difference in their lives. And I know this is not in your job description, but it is our challenge in trying to pass this legislation, which all of you agreed meets a problem that we need to address. So I'll just throw that open-ended question to you.
I think one of the best things that this bill does is it just shines a lot of sunlight on what's happening in the middle. So one of the problems today is that if I'm an advertiser in Connecticut and I buy an ad from Google's broker, from Google's exchange, often I don't even know where that ad ended up. So I don't know if it ended up on the Hartford Courant, or I don't know if it ended up on a Russian website that I don't need to advertise my products to. And so one of the things that it does is it requires disclosure so that advertisers can know what they're buying. Another thing that it does with respect to transparency is it forces the brokers on each side to actually tell their customers what bids they submitted and what the bids cleared for. So today, the Hartford Courant might use a broker to sell ads, and those ads might sell at, let's say a $20 cost per thousand, and the Hartford Courant might get a $2 cost per thousand and might not even know that that's what the advertiser paid or what the delta in the middle was. And so the transparency section of the bill requires disclosure about basic things like price, bids, and what was sold. And that itself should reduce a lot of fraud and generate a lot of competition.
Thank you. Others? Mr. Lynn.
Yeah, I think there's a reason one of the reasons I brought up discrimination, price discrimination, is because in many ways, the problems that have been so well described thus far, they're actually worse than we understand, which is in this system, there is no pricing. When you have a monopoly, and when one actor in the system has all of the power, has all of the data, has a specific relationship with each actor, none of the pricing is being set within a marketplace. It is being set between the master and the subject. So the problem is actually vastly graver because we can't even measure the economic harms that we're dealing with here.
Thank you all. This is a topic which really deserves a lot more explanation and exploration, and my time has expired. But thanks again to Senator Klobuchar for all her work, very thoughtful work on this issue.
Senator Lee and I were amused as you and Dina were geeking out on Connecticut with the Yale and Hartford references, noted by Professor Henderson as well, I note.
Well,
the rivalry, you know. Okay, Senator Lee.
I mean, the University of Chicago is close to your home state, and it is your alma mater. I'm sure it's littered with monuments, statues, and plaques honoring Senator Klobuchar.
Yeah.
Mr. Alford, what does antitrust law have to say about when, under what circumstances, divestiture or structural separation is an appropriate remedy for anti-competitive conduct?
Yeah, thank you for the question. So obviously, divestiture is a preferred approach with respect to any sort of merger analysis. Administrations on Republican side and on the Democratic side preferred divestiture because it's so much easier to monitor and to avoid these sorts of conflicts of interest and to promote effective competition. Divestiture is also a common remedy that occurs in the antitrust context. There are lots of examples, famous examples of divestiture that occur in the litigation context. Of course, with respect to the ad tech litigation right now brought by the Department of Justice and by the different state AGs, they're all requesting divestiture as a result of the misconduct of Google. If I can comment on Professor Henderson's comment that divestiture is inappropriate here, he says two things that I think need to be clarified. One is Goldman Sachs can own the dark web exchange, but that is in the backdrop of regulatory limitations, right? He mentioned transparency, but obviously the best interest duty and all the other sort of duties that would apply. So it's almost like he's saying, I'm fine with everything else about the bill except for the divestiture component of the largest companies. But if you're going to allow that, then you have to have these other things that provide the backstop to protect against it. And of course, this bill only deals with the very, very largest ones having those restrictions. Everyone else below that, the middle and the smaller ones, can do exactly what he said. So, we're not talking about a radical proposal here with respect to divestiture. And what we're doing is similar to what you would have in antitrust competition cases where there's a serious problem.
So it's more of a safety valve at the top of the market.
Exactly. Yep.
And when it's a safety valve at the top of the market, it makes sure that there can continue to be a lot of other things happening.
Right. No, notice he did not say that Goldman Sachs could own the New York Stock Exchange, right? He did not say that. He said that they could own certain small, minor dark web exchange.
Well,
Can I just, since he said.
Sure.
I just want to just
You're right.
clarify what I said. So first of all, dark web is the wrong term. They're called dark pools, but they're alternative trading systems under a regulation passed by the SEC. So this is not some nefarious place. And moreover,
Illegal stock trading.
Yeah, and 50% of stock trades happen on alternative trading systems. 50%.
What's it called? What was it?
Dark pools.
Dark pools. Okay.
And the reason they're dark pools, they're just called that because you can trade anonymously, because sometimes people want things other than price. Just one other thing I wanted to note. I feel a little bit like we're having, just trains passing in the night here. The comments are that Google just completely is the master, and the poor New York Times is the servant, and they just have to take the terms that Google gives them. And this is just not correct. The New York Times has innovated themselves in creating header bidding, so they sell their own ads on their space. There is plenty of competitors, as I've mentioned numerous times, and the big competitors here, Amazon, AT&T, Facebook, they all preference their own sites and give their same preferences that Google's doing. So Google's behaviors, whether they're good or bad, that's for other people to judge.
Google
They're all
blocked
the same.
header bidding. It blocked header bidding.
For
That's
sure.
part of the lawsuit.
That's right, and in certain locations. But now they've agreed. I think it was with the French Competition Authority, and now they've changed on that. Is my understanding.
They've repented worldwide of that?
Because of Europe, because
that's fine. And if antitrust regulators find particular conduct that is bad, then that's fine. But we're talking about something that is, that's treating an illness. This is just lopping off the head and surgery here.
All right, I want to put a pin in that, and we may come back to it if we have time later.
the lopping off the head.
And I also want to get back later. I'm not sure your comparison to the stock exchanges works. I mean, it is, as you pointed out, a market that is 700 times larger than this market, and the market concentration is a lot less significant there. Anyway, I want to get back to that, but let's go back to Mr. Alford for a minute. I noticed that in his recent memoir, former Attorney General Bill Barr described a possible approach that Congress could take to laws dealing with big tech. And he suggested it could involve, quote, ordering platforms to divest certain previously acquired firms with the aim of reducing the platform's market dominance and promoting competition, not directing specific divestitures by name, but defining the particular characteristics requiring divestiture. And the law that he describes could also impose rules, quote, governing the collection, use, and analysis of personal information, he writes. Now, I did not put him up to this. He did not consult me when writing his book, but that sounds a little like the America Act, does it not?
I think it is. I think it is the America Act. As he was finishing his tenure there, he was actively wanting to also pursue ad tech litigation, and they were in the middle of that investigation, and it was picked up by the Biden administration. Of course, they filed suit this past January. But absolutely, and I'm sure if you asked him, I'm sure you know him, you could say, yeah, this is exactly the kind of legislation that I think I was writing about, because it's what he was saying in his memoirs.
Now, Mr. Kint, one of the defenses that we hear of Google, and specifically Google's ad tech business, is that they pointed to all the innovation that has occurred, and that innovation brought to the marketplace has lowered the cost of advertising. Prices have gone down. It seems like I'm not sure that argument holds water, because Google tends to buy up those who do new things. Google isn't necessarily introducing anything new on its own. It acquires firms that do, acquiring up would-be nascent competitors, so they can get their innovation. The innovations originating from Google seem to be more focused on building gigantic walls, fences, moats with alligators, crocodiles, and sharks with lasers mounted on their heads around their market position. And then the lower prices and the lower prices they don't account for the need to buy more ads because of the declining quality of the ad placement. So people are having to pay more per ad having to buy more ads overall because the quality of the placement impacts the impact that they have. Is that consistent with your observations of the market?
Yeah, absolutely. And there's a lot of jargon that can be thrown out, a lot of different metrics that Google can throw out. Frankly, I've seen it all. I installed the first ad server back in 1996 before Google and before DoubleClick, and I've seen every sequence of every single company that's tried to create some sort of new angle into the ad tech landscape that Google has then typically acquired and squashed in different ways, which is well documented in the various antitrust lawsuits. And so I would take you back to kind of a real world example, and it's from Europe actually, with their privacy law GDPR when it came out. You had Europe trying to innovate around consumer privacy, and even the largest publishers, including the one that Professor Henderson mentioned, they had no control over how privacy law rolled out. They basically had to wait until Google, literally when they had 2 years to tell the market what they were going to do. 1 month before GDPR rolled out, Google said, you're going to get us consent as a publisher. You're going to give us all the data. We're going to bundle it. We're not going to tell you how we're going to use it, and you're going to be liable for it. And so that was how Google decided to roll out privacy in Europe. And they decided, and you think about the informational advantages, asymmetry, and the data and the value of that continue to flow to Google at a point when there was a lot of risk for Google if GDPR played out the wrong way, because it went right at tracking. Sorry, go ahead.
But instead, they used GDPR as
That's exactly right.
additional mortar for the moat and the wall and the other moat and the other wall.
That's what they do.
And
Exactly.
the sharks with the lasers on their heads.
Yes. Yes.
That's
Consistent.
pretty well played and further entrenched them.
Further entrench them around something that should have been better for consumers.
Electrified fence, also, we won't go too far, but
They still have access to as much data as they want, and they can use it however they want. And at the end of the day, they just create an obstacle for publishers that extracted more value for Google.
right. Yeah, that seems troublesome. And it also seems like the kind of thing you could do. You couldn't get away with that if you didn't already have a degree of market dominance.
Exactly. And your legislation, excuse me.
Go ahead.
Your legislation, I mean, that second tier that says, even if you're above $5 billion of volume, you have a best interest obligation. You no longer can take that data and then use it for an entirely different purpose in an entirely different context for a different client or for your own profit enrichment. So the legislation directly, I think, improves that. And I think that's, you mentioned this earlier, but I think there will be consumer privacy benefits out of this legislation.
Okay, why don't I just go now? And then you go. Okay.
Thank you.
Thank you.
Just for the record, Bill Barr didn't consult me before he wrote his book either. I just want to say, okay, just get it out there. Although I am in it, it's not that bad. Okay, so why don't I start? I thought I'd mention something about AI here, Mr. Kent. In addition to Google's power in digital advertising, it looks to have an early advantage along with Microsoft and other monopolies in deploying AI like Bard. Those systems are trained on content developed by many of the publishers in your coalition. We know AP, News Corp, USA Today, you name it. Are you concerned that Google could use its advantages in digital advertising, consumer data, and computing power to deploy AI in ways that is going to exacerbate what we're already talking about here today?
Deeply concerned, and there's a pattern of behavior there that we've seen with Google, and we saw it with Facebook. It's treat all websites, all web pages as an interchangeable commodity, layer on your targeted advertising. So if they can absorb the entirety of the web, and they'll say that the publishers you just mentioned are just a very, very small fraction of what's out there on the web, when the reality is that's the signal and the noise. That's the instructional data from the journalism. That's deeply concerning. So we're thinking about kind of three things. We're thinking about how do you protect that intellectual property and that art of the journalists and the photographers and our various members. We're thinking about, and so that plays into copyright. We're thinking about...
And we know there's an exception under Section 230 for copyrighted material, but the answer just can't be that, having talked to one of my smaller newspaper, nothing like the size of the New York Times, Professor Henderson, already on its back because of the issues that we're
Right.
raising today, and really badly needs the bill that Senator Kennedy and I have passed, the journalism bill.
That's right.
But they don't have the kind of resources that the big guys have to take this on. They're not going to be able to sue. Just hearing him talk about, and the conversation about something totally different, but hearing them talk about how they're doing experiments to see on some of their own stories what is right now on ChatGPT, not a Google product, or some of the other sites, and they're looking at what's going to happen here and seeing echoes of their own news coverage, which they know is deeply local, getting picked up on this. So continue on as your descriptions of what some of the solutions are.
Yeah, so that's right. It's protect the ability for them to say, you can or cannot use our content in order to train your models, which is really hard to do against market power, especially when a company dominates in search, which is the subject of a different antitrust lawsuit with Google. But number two, how do we advance the future broadly for professional news and entertainment? Because this is part of the future. And then in that vein, I think there is opportunities and revenue opportunities for premium publishers that do create high quality news and entertainment that need to also be explored. But you have to come to the fight without your hands tied behind your back against monopolists.
Exactly. And I guess I'd go to you, Mr. Lin. We talked about what we're seeing with journalism. I mentioned the stat that a recent study by Northwestern University predicted that 1/3 of the U.S. newspapers that existed roughly 2 decades ago will be gone by 2025. Senator Kennedy and I introduced the Journalism Competition and Preservation Act to allow news outlets to band together to negotiate free compensation from the platforms that are monetizing their news content for free. Talk about why this legislation is needed to strengthen local news across the country.
Thank you for that, Senator. This legislation is necessary because the newspapers are being starved. It's like the middlemen have established themselves, just very simply put, in between the advertiser and the publisher, and they are diverting the money into their own pockets. Mm-hmm. And so what's happening is places like the Minneapolis Star-Tribune and the Seattle Times and the Dallas Morning News, pretty much every single newspaper in America is being starved. And this is as you know, is bad for democracy. So this piece of legislation that you've put forth is actually the first piece of legislation that is taking a step in the right direction of preventing this extreme concentration of power. And just to be clear, whatever the New York Times is in a privileged position, but having one newspaper left in the United States is not the outcome we would like to see.
And I will note there's been support from both big news organizations in the ilk of New York Times, Washington Post editorial boards, but also very small news organizations as well, and everyone from News Corps on, very different political ideologies, not only of the senators that support this bill, but also for those news organizations, and that this is pretty much an across-the-board belief. And it's, to me, I see this as a duo approach. One is a newspaper bill, and then the other is the America Act and these. And the final thing that I think is worth very much talking about is the American Innovation, Choice, and Online Act. So Google, as we've noted many times here, advertising giant, also gatekeeper, like on search, where it has a 90% market share, or on its app store. I've worked on this bipartisan legislation now with Senator Grassley. We mention it, that would require digital gatekeepers to compete fairly with small businesses and stop anti-competitive self-preferencing that allows companies like Google to drive traffic to their own websites, which drives up their advertising revenue. I guess, Professor Alford, would this kind of legislation would this reform lead to healthier, more competitive set of digital marketplaces generally?
Yes, I think the different types of legislation that you're proposing, the America Act obviously is targeted specifically at one specific market, and I think that would be incredibly beneficial. But there's a lot of benefits that you're talking about with respect to the Innovation and Choice Act. You know, specifically you mentioned the self-preferencing problem. Self-preferencing problem is very, very acute in this market. We see it all the time, that they're steering clients, their own clients, to their exchange instead of a competing exchange, even though the clients would be better served if they were allowed to go to other exchanges. That's what Senator Lee was talking about when he said they're trying to kill header bidding. And so if you had limitations on that ability to do that, then it would be definitely an improvement in the market.
Can I just say one thing about newspapers? Yes? Is that a yes?
You can, yes, but you keep mentioning one newspaper.
I'm gonna
that
mention.
isn't even covered by the journalism bill.
I'm going to mention your hometown paper, Senator.
Yeah.
So first of all, love newspapers. I subscribe to 4 at my house, including 2 local ones. So I'm all for newspapers. Antitrust law is not supposed to be about newspapers or producers. It's about consumers. So just that's an important thing to keep in mind, is focusing on consumer welfare, not producers. I understand why the newspapers don't like Google. We're talking about consumer welfare here. But I just want to mention one fact.
I think there's just many of us have a very strong belief in the First Amendment.
I'm with you, Senator.
Professor Anderson, in that consumer welfare, in my mind, is about the consumers and the people who participate in this democracy, their own welfare, and that means they have to have local news that is covering corruption on a city council, or covering when a business is closing down, or covering when a football team wins the championship in their local high school league.
We 100%
so
agree.
it brings people together in not as only as a news source for understanding what's happening, but it also brings them together in terms of being members of the same community.
I totally agree. I just want to mention this Minneapolis Star Tribune. While we were talking, and this claim about Google being a monopoly and really hurting local newspapers, you can go to the Star Tribune's website, which I've pulled up here, and look at their ad agencies that they use, their online ad platforms. And it's pages and pages and pages of Google's competitors, including Google. So the Star Tribune uses dozens of ad platforms, including Google, and it's publicly available information. You can look. So the idea that the Star Tribune, when it's placing its ads and selling its real estate, is limited to just Google, and that Google is able to use that in a kind of master-servant relationship, as we've heard discussed here, is just false, and the Star Tribune's own website will show you that it's false.
Mr. Lin, what is about the market share of Google right now, of the search engine market?
Depends who's counting, but it's probably about 90%.
That's what I thought. Okay.
Actually, could I make one quick? The idea that anti-monopoly law is not pertinent to protecting the free press is an outrageous statement, and it stands contrary to the entire history of the United States, going back to the Constitution, which established the Postal Service as an independent and a neutral system for the distribution of mainly news.
Okay.
So, and we have used anti-monopoly law time and again to protect American journalists and publishers against concentrated power. Sir.
Okay, thank you. Mr. Kent.
One quick point, thank you. All those ad tech companies that are being brought in on the page of the Minneapolis site are being mostly ushered in by Google. So Google's still a choke point. That's just a disclosure that all these companies are touching the page. And then second, I think we use newspapers as a proxy for news generally. Our organization is entirely focused on the digital world in the future. I don't care in the same way about the actual printed newspaper. I'm focused on the future, and I can tell you that the digital-only companies, the ones that launched in the last 10 years, are seeing the exact same issues. BuzzFeed News just shut down last week. It's not, the business has underlying problems that's not related to printed newspaper.
Thank you. That's a good point. And I just want to emphasize, as Senator Lee is aware, just the different ideology in elected officials being willing to take this on, which includes, of course, state attorney generals with very different beliefs. And Professor Alford, both the Justice Department and many state attorneys general have sued Google for monopolizing the ad tech market. You've been involved in some of that litigation. Could you speak to the need for both litigation and legislation to address those market issues?
Yes, so I think everyone that is concerned about these markets is supportive of both regulation and litigation. They're complementary to one another, not competing with one another. Obviously, antitrust litigation focuses on the most egregious harms of the largest, biggest players, whereas the regulation that is being proposed here and the other regulation that you've been involved in tries to look at the larger picture and try to deal with larger questions, right? Not just harm to competition, but also public discourse, concerns about privacy, and also conduct not just of the very, very largest, but other players that might not be in the dominant position. The litigation is slow, it's cumbersome, it's extraordinarily expensive. You have to have very, very certain thresholds you have to meet with respect to monopoly power. And even if you win, you have no guarantee whatsoever what kind of remedy you're going to get, if it's going to be some sort of injunctive relief or some sort of divestiture. And even then, there'll be an appeal to the circuit courts and then appeal to the Supreme Court. Thanks to your work on the Venue Act, Texas is trying to get back to the Northern District of Texas, but we started that case in 2020, and we're not even scheduled for trial till 2025.
Yep.
And we barely started discovery. So, they're complementary. I mean,
I'm just picturing as all these news organizations are folding and we're waiting for this litigation.
Right.
And we're just sitting there. And that's to the benefit
the
company.
litigators support regulation too. I mean, the Department of Justice has written in favor of litigation.
They've written in favor of the self-preferencing bill.
Yep.
They've written in favor of a number of these bills, yes. Ms. Srinivasan, just a few hours ago, the FTC announced that it is seeking to modify an order about how Facebook monetizes data about its users. I believe there's actually a connection between having that market power and then the way they handle sensitive data. Do you think if there were more competition in the digital ecosystem, companies might compete to be better on privacy?
Absolutely, Senator. I think more competition we've seen empirically in the market lead to more privacy. It's something that I spent a lot of time studying, especially with respect to Facebook. When Facebook faced competition, it offered much higher levels of privacy and it competed explicitly on privacy.
Exactly. But when we have Mr. Zuckerberg making statements that the House discovered during their lengthy hearings on this subject, I'd rather buy than compete, in reference to his purchase of several other what were then small competitors. I think you get the results when you don't have laws in place that can police this or any enforcement. And now there's been a shift, as we've all noted, with cases going on in both the last administration and this administration. By acting on the buy side and the sell side of the ad tech stack, Google faces an inherent conflict of interest that's been referenced by Senator Lee and myself. While publishers want to sell their inventory at high prices and advertisers want to pay as little as possible, Google makes more money if advertisers pay a high price, but publishers actually receive a low price. Plus, Google is also selling its own ad space. Ms. Srinivasan, what evidence have we seen that Google uses its position in these markets to maximize its profitability and increase its market power?
Well, we could chat about this for a while, I suppose.
It is 4:10 in the afternoon, so you can keep the answer short, I'm sure.
Gosh, there are a bunch of examples. Senator, what were you looking for precisely?
Well, just examples and about how they're kind of double dealing on both sides, and how it uses its position in the markets to maximize profitability, increase market power.
Yeah, I guess I would just make two comments. In the allegations in the state AG complaint led by the state of Texas, there were a bunch of auction manipulations that are alleged with fun names like Project Bernanke, where Google was supposedly using information on one side to manipulate the auction mechanics in the middle. The other thing that I would say is that we actually see them extracting a higher fee in the middle, not taking less from one side and giving more to the other, or taking more from one side and giving less to the other. The actual intermediary fees are inflated.
Mm-hmm. Okay, very good. All right. I think I'm going to turn over to Senator Lee for some closing questions.
Mr. Srinivasan, so there's been a lot of talk about Google when it comes to digital advertising. Let's talk about some of the other big tech firms for a minute, keeping in mind, like any market, this isn't static. You've got other companies moving, and it's always good to keep our eye on where things could be going next. Apple seems to have realized that the market for the iPhone is quite saturated. I mean, it's a good position for anyone making phones to be in, where pretty much everyone who wants an iPhone now has one, and so most sales are going to come from replacements. And so it's now using the vast network that it has and citing privacy concerns in order to gain exclusive control over our data so it can monopolize ads that we see on our iOS devices. And correct me if I'm misstating any feature of this marketplace. You've got Amazon that increasingly serves as kind of a clearinghouse for goods made in China, opting for higher margins from selling ads to Chinese manufacturers. And then you've got Facebook, which of course sits on a treasure trove of data. Now, Facebook has always been dependent on ads. It would likely have an even greater presence in the ad tech space in digital ads had it not reached its own agreement with Google preventing that. Should we be concerned about any of these other firms' activity in digital advertising at this point?
Well, I would say that this bill doesn't aim to fix, all problems, but most of the companies that you mentioned do operate what would be termed and captured by the bill as exchanges that are bringing together third-party buyers and third-party sellers, and they would be subject to the same conflicts of interest rules and the same rules around having to sort of siphon off and manage and protect data in different divisions.
Okay. So they're not in the same position as Google, but would be in the same position in the sense that they're covered entities.
They would be covered entities in some respects. So, for example, Facebook does act as a broker under the bill on the buy side, and they do bring together buyers and sellers, buyers and third-party sellers in real-time auction markets. And Amazon also plays multiple roles in this respect too. So Amazon is not just selling ads on Amazon.com, but it's also intermediating ads on behalf of third parties, and so it too would be captured under certain aspects of the bill.
Okay, thank you. Mr. Kent, let's talk about a little bit more about data. You've written a fair amount on this, and you've written that collecting data in one context but then using it in another context, e.g. behavioral advertising, tends to violate consumer expectations. How would the America Act prevent a company like Google from collecting data in one context and then using it in another in the harmful ways that you described?
Yeah, I guess two ways. The best interest and execution obligations will require that they don't collect that data and use it for a different purpose. So the data is only going to be collected by Google or Facebook or whoever the company is that's in that tier for the purpose of the publisher and maximizing value for the publisher. So that data stays, almost has a ring fence, if you will, around it so that it can't be taken and used for other value elsewhere. And so I think that's one way. And then, the restrictions on being on both sides of the market too will eliminate the example that I used in my opening remarks around tying, where, one company can say, I control most of the demand in the ad marketplace, and so therefore you need to give me all of this data as part of the conditions, as a precondition of the deal, which is quite abusive, and it's quite documented in all the AG.
Well, and you wouldn't get away with that.
You wouldn't get away with
it. If there were a free market. Nobody would get away with that because they tell you to pound sand.
If the consumer knew it was happening and the publisher actually had any sort of market power, yeah.
Right.
And again, every single publisher at any size can't stop that.
Right. And presumably the customers of that entity would also insist upon it. But it's hard to tell someone to pound sand when...
Yeah. We've done the research on it, Senator. We've asked, when you're not using a Facebook product, would you expect your data to be collected and used for a different purpose? And the answer is no from like 60% of the users. We asked the same question about Google. Users do not want to be tracked across the web. If they choose to use a product as part of real choice and real competition, and that data is used to deliver the service to them, that's great, that's fine. I'm a subscriber, you can use my data to authenticate my subscription, wonderful. I'm a customer of this product, you can personalize it based on the data that I'm giving you to make the product better. If I don't like what you're doing, I'll go elsewhere. They do not expect that data to be collected and used in a totally different purpose.
So that prevailing assumption with regard to Facebook that you just described is not accurate.
Correct.
Right. Now, you've also said that, quote, the issue of tracking and data collection and use by third parties is a really important issue, and that consumers should have a global privacy control and an ability to opt out. But you limited that to opting out of third-party data use. Is that right?
I did.
Here it seems that the first-party data use is really the fundamental problem, because companies like Google or like Meta can use all the data they collect on their properties to feed their advertising engines. So how could a law like the America Act address this problem?
Well, again, I'll go back to the data point from the UK Competition Authority report that showed that Google and Facebook uniquely collect a majority of their data from third parties. They get a majority of the data they have for targeted advertising from third parties, according to that report. So it's collected in a third-party context when the customer is not choosing to use a Google or Facebook product. And so one, it cuts that all out because the user can no longer be tracked from one context to the other. And then the first-party data is still an issue. I mean, if you're on Google search, because 90% of the searches happen on Google, they're going to have a lot of first-party data on you. You still need to have choice in search, but that's a different issue than we're trying to address here.
Okay. Hang one second. Mr. Henderson, let's go back to you for a minute. This stock market example. Is that really fair? I mean, you've got 700 times, the scale is much larger. The market concentration, market power of any individual firm in that setting, it's a lot more distributed, isn't it?
So first of all, Senator, I didn't make up this analogy. My paper responds to the claims that the proper analogy here for the regulation.
Yeah.
Okay, so I was just responding to that. And the claims that there are not vertically integrated, et cetera. With respect to market concentration in the securities business, the publicly traded securities, so not in the dark pools, the top three companies, the New York Stock Exchange, NASDAQ, and the CBOE, have an overwhelming market share. So there is concentration, and the reason there's concentration, it's the same reason there's concentration in this market, is because there's economies of scale and network effects. And that can explain why there are very few competitors. In the dark pool, the alternative trading systems under Reg NMS, again, the couple, 2, 3 largest firms, Goldman, Bank of America, JP Morgan, have overwhelming market shares there as well for the same reasons, economies of scales and network effects. So I don't want to push the analogy to stock markets and say that's a basis. I was merely responding to the claim that this vertical integration across the whole ad stack is some kind of monster we don't see anywhere. And I'll just note one final comment, which is the New York Stock Exchange, it is true that they do not own a broker-dealer, but the New York Stock Exchange sells tools for both buyers and sellers of stock. In fact, which is what Google does. In fact, if you are a small-time trader and you do not have your own algorithmic trading department like the big traders do, the New York Stock Exchange will sell you their version of that, which is you're like a small advertiser, exactly the same way that Google does. So this behavior that we see with these kinds of potential conflicts of interest exists everywhere. And I want to say I'm sensitive to the concerns that you have about privacy, pornography, all the things that you said. I've got 3 kids myself. These issues that you're raising are serious concerns. And if Google or anybody else, I'm not here on behalf of Google, if Google or anybody else is being deceptive and they're misleading people about how they're using their personal data, we've got laws against that. I'm here just to point out some of the costs of the America Act that I think aren't being considered.
No, I get that. But there are some significant differences here. I mean, The stock example, you've got, it's a pretty diffused marketplace. It is highly regulated, and it's quite fragmented. And you don't have one firm dominating the lion's share of the activity, the buying and the selling.
It's true, and I just want to say, let me just say one thing about the highly regulated. I completely agree with you. As I lay out in my paper, the reason it's highly regulated has nothing to do with these conflicts of interest, because when I go into CVS, there are also conflicts of interest with them selling branded products and generic products and using data and using cameras to check my eye line and where they place everything and the data there. I happily turn over my cell phone number to them to get a 2% discount. And they collect that data. They know exactly what I'm buying. They use that to target me. This is ubiquitous in all markets. The point about regulation I want to emphasize is the SEC has been trying for 20 years to implement a best interest rule in the stock market. For 20 years, they've been trying, and 43% of trades trade at the best interest rule. And this isn't a market that is trivial compared to the complexity of the ad market. So if you sign on for a best interest rule, and the only reason we have it in the stock market is because there's not physical separation. So you're using a kind of belt and suspenders approach here. But if you sign on to a best interest rule, you're signing on to a massive regulatory apparatus that cannot be administered by state attorneys generals or the Department of Justice. It will require an administrative agency to oversee the vast amount of data, because the SEC is that with 4,500 employees, and they are not successful at implementing a best interest rule after 20 years.
I guess that's one reason why it's sometimes fair to insist on structural separation instead of a massive regulatory body.
I think that's a mistake for reasons I've said otherwise. I'm merely pointing out that if you go with the best interest rule, you are signing on, in my opinion, based on my experience in the stock exchange, which is much simpler, to a huge, massive regulatory apparatus to enforce a best interest rule.
It's just not the case with this bill. No. That's just not true. That's utterly at odds with what the bill says.
I'm just taking the language of the bill as it is, which is enforcing a best interest rule that would require an exchange to trade in the best interest of its clients. That's the rule that the stock exchange has. It's Rule 611 and requires the same best execution rules for stock trades. It's the exact same. On that narrow point, it's the exact same.
Okay, Ms. Srinivasan and Mr. Kent and Mr. Lynn are all chomping at the bit to answer this, and I have to know what they're saying. This will be it, I promise.
No, I want to see it too. I was going to actually have them do it because they just seem so eager to defend you. Yes.
All right, Barry, let's start with you.
Thank you, Senator. Professor Henderson said that this kind of vertical integration across the ad stack is not some kind of a monster that we don't see elsewhere. He said it actually exists everywhere. Pre-1980, it existed nowhere. It was against the law. It was against the traditions of the United States going back to the beginning. And that's why what you just said, that's why we need to insist on structural separation, is absolutely correct. And I bless you for working on this bill.
Thank you. Thank you. Ms. Srinivasan?
So the bill actually applies a best interest rule not to exchanges, but to the brokers. And to my knowledge today, I am not aware actually of any of the sort of entities that are helping buyers or sellers that proclaim to do anything but act in their customers' interests. And so in effect, the only thing that this bill really does is shed sunlight onto what's actually going on so that the customers can complain and hold their brokers to account when they're not actually doing what they're promising that they're doing. The other thing that might be helpful to just be clear about is that in financial markets, there's really a two-tiered approach. So Goldman can't own the New York Stock Exchange because the New York Stock Exchange is big and important and it has a lot of market share. And then the smaller guys can do both. They can be brokers and operate dark pools or ATSs. And those guys have to manage their conflicts of interest and disclose a lot of information so that we can hold those conflicts of interest to account. The bill takes the exact same approach, really. It says that the very largest firms that own the very largest exchanges can't simultaneously be on all sides of the transaction at the same time. But smaller ones, like in financial markets, can both be a broker and an exchange. And in those situations, what we need to do is, that's not being done now, is we need to manage conflicts of interest. We need to make sure they are managing their conflicts of interest. And we need to make sure that there's enough transparency and disclosure so that customers themselves can audit and police the behavior of intermediaries.
Which they would have a greater ability to do under this bill.
That's correct.
Currently, they don't have the ability to do that. Mr. Kint.
Yeah, and the last point, thank you. I'm not going to go deep on the stock piece again, but I still, the thing I understand enough is that if these dark pools, that if there's some self-preferencing or preferencing or favoring, that would be illegal. And so we need something to actually make that same behavior illegal in the digital advertising world, which it's currently not. And yes, to Ms. Srinivasan's point, the SSPs, we call them, they're brokers on behalf of the publishers. They're supposed to act in their best interests. But in the case of at least Google and a few others, when the publisher says, are you actually doing this? They have no recourse. There's no way to get the data to prove that that company is not taking the data and the value and using it elsewhere. And so time and time again, we see that issue where they might not be acting in the best interest. And so that's the core underlying problem. And I think that's resolved by the legislation.
Thank you. It keeps occurring to me that I keep confusing the dark pool with dark web and Deadpool. I'm going to try to keep those separate in my mind. Thank you.
All right, on that note, thank you all. I think it's been a very enlightening hearing. I think you know that these bills are more important than ever as we see the momentum off the end of last year, where we actually did get something done on merger fees in the venue bill. And now we have several major pieces of legislation that we have interest in advancing. We have growing support. We have growing money spent against us, as I showed from that lovely advertisement that my guess is most people had not seen on the witness panel, but somehow a bunch of my colleagues did. An example of how targeting advertising works and what we're up against. But with the advent of AI, with the need to continue to support our Constitution and the First Amendment and the balance of powers in this country, with the need to take on monopoly power, I think that our momentum is growing stronger and stronger. People just are afraid to talk about it sometimes. But in the end, there will be votes, and we must get a number of these bills passed. So it's been really, really great to have this civil discussion, despite some disagreements. I think you understand we had a number of members here that couldn't all ask questions. I'm sure some of them will on the record, including we were joined by Senator Hawley and Senator Tillis and Booker and Blumenthal and Hirono, and we thank them for being with us today. And I thank my colleague as well as Senator Welch. I thank my colleague Senator Lee for his leadership and always being a good pal to hold discussions with. And when we do agree on things, we actually get a lot done. So watch out. With that, I will hold the record of the hearing open till May 10th. You want to add anything, Mike?
No, just that this has been terrific, and I want to thank my staff and Mark Metter for helping to put this together, and each of you. This has been an absolutely fascinating hearing. This is the most fun I've had in a long time doing something that doesn't involve ice cream, so thank you very much for joining us.
All right, and again, thank you to Kagan and to Mark and to Avery on our staff for all they do. I know they've worked with a number of people in this room, always open to new ideas, always open to criticisms, right? Because we get a lot of those. We get a lot of incoming. And we're excited the progress we're making, the members that we're educating about these important issues. And with that, the hearing is adjourned. Thanks.
Thank you.